Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, a couple days ago, we got to do this amazing video where we actually talked about the Ninth Circuit. That's right, the Ninth Circuit striking down a federal gun law. It was almost like it was too good to be true. Well, perhaps it was, because now, as we know, there's always that full panel of the Ninth Circuit hanging over the top, and oftentimes is the case. I think they're going to end up raining on this parade. I'll explain what I'm talking about in just a moment. So today, let's spend a few minutes and let's talk about how the full Ninth Circuit will turn this miracle into a mirage. Okay, before we get going too far down the road we're going down, proud to announce that this video is, well, before we go there, this is the God's honest truth. I actually found this company on Kickstarter, contacted my business manager, Alex, and said, Alex, get a hold of these people. I really, really want to talk to them. What am I talking about? I'm talking about PaintCam. Revolutionize your home system with cutting-edge technology. Introducing the ultimate home security system, PaintCam Smart Home Security. Their cutting-edge security system for home provides unparalleled protection, ensuring your family's safety and giving you ultimate peace of mind. PaintCam's advanced technology detects both humans and pets using state-of-the-art facial recognition to distinguish between welcome guests and potential intruders. In the event of an unwanted intrusion, our system springs into action, deploying paintball markers or tear gas to deter the intruder and mark them for easy identification by authorities. I'm not making this stuff up. How cool is that? PaintCam's Eve Smart home security system funded on Kickstarter in less than an hour, and now at 650% funding. It comes with 3 models, Eve, Eve Plus, and of course the Eve Pro, each with unique functionalities. Features include animal pet detection, face recognition, regular, UV, and upcoming pepper gas paintballs, night vision, sound warning, high-resolution camera, and of course, user-controlled autonomous mode. App integration for easy security settings, adding faces, confirming access, and more. Easy installation process. Currently available on Kickstarter, this is important, at 40% off the regular price. Estimated shipping January 25th. Hey, if you don't believe me, check out some of the features they've done with Fox News, Uncrate, and the Washington Times. Listen, this is really absolutely one of the coolest security devices we've ever seen. Check out that link right there for more information. Visit our good friends at paintcam.eu. Okay, so the case we're talking about again today, we just talked about it a couple days ago, is the case of United States versus Duarte. It is a case that was argued in front of a 3-judge panel before the Ninth Circuit. Is it a challenge to 18 United States Code Section 922 G1, which has, of course, that convicted felons, regardless of what the felony is, violent or nonviolent, whatever, cannot possess firearms. It is a case that has been brought all the way to this point by Mr. Duarte's federal public defenders. And once again, kudos to all of them for the great work they have done. A 2-1 decision out of a 3-judge panel before the Ninth Circuit found that 18 USC Section 922 G1 as applied to Mr. Duarte was unconstitutional. Glorious day. Well, it only took about 48 hours for the United States Department of Justice to immediately file for an appeal to the full panel of the Ninth Circuit, and we know how that goes. And for those of you who are not familiar with how things work in the state of California in particular when it deals with the Ninth Circuit, some of you may recall what professional wrestling was like pre-WWE back in the 70s, early 80s. You know, you'd watch it on WTBS from Atlanta, Georgia, Gordon Soley and all those guys. And at the end of every episode, there'd always be the big battle royale between the good guy and the bad guy. And of course, the good guy'd be winning until another bad guy would suddenly come out of the locker room, and there'd always amazingly be this one empty folding chair just right ringside, and he'd hop into the ring and it'd turn into 2-on-1, and they'd start bashing the hell out of the good guy, and then the credits would roll, and that'd be the end of the episode. Okay, well, that second bad guy coming in and grabbing the chair, yeah, he's the Ninth Circuit. Want to see what the issues are here, or at least how the United States government is framing it? Well, you just start right at the beginning of the memorandum. Look at the issues presented. 1. Whether 18 U.S.C. Section 922 G1's prohibition on firearm possession by a felon violates the Second Amendment as applied to the defendant who has 5 prior felony convictions. 2, whether Federal Rule of Criminal Procedure 52B requires a plain error review of the defendant's Second Amendment claim, which he failed to raise in the district court. Now, we're not even going to deal with the second one there, but that is a quasi-standing-like challenge. And as we know, anytime the United States government is arguing standing, it's because they don't actually want to argue the merits of the case. It has to do with whether or not Mr. Duarte's counsel at the lower level had raised all the correct arguments so that could be reviewed here at the higher level. We're not going to geek out on that because it would bore you to death. Now, for those of you who geeked out on the other video, you'll recall that there was this old case, United States versus Vong Se, which, if still good law, would absolutely shoot Duarte's arguments out of the sky. Now, the three-judge panel kind of believed, like, well, Vong Se was decided before Bruin. It clearly relies on a lot of statutory interpretation that we do not or cannot rely upon anymore. And so they did a whole renew analysis. Of course, the United States government is like, hey, that is ridiculous. What are you doing? It's still good law. And so to give you an idea where the United States government's coming from, it's this. Contrary to the panel's conclusion, Bruin did not abrogate this court's decision in Vong Se. Vong Se relied on Heller's assurances that it was not calling into question long-standing prohibitions on the possession of firearms by felons to conclude that prior circuit precedent upholding Section 922G1 remained binding. Vong Se held that Heller's statements were not dicta, but were integral to Heller's holding. And you sit there and go, yeah, I know, but you remember the three-judge panel wanted to really go back and really do a reanalysis. The United States government is saying, ridiculous, you don't need to do that. You can just skip to that because we're correct, and this is why. It does not matter that Vong Se did not undertake a full textual and historical analysis like that conducted in Bruin. Vong Se relied on statements that were integral to Heller's holding and that members of the Bruin majority specifically reaffirmed. So obviously they're trying this quasi-standing argument, also saying that case precedent just shuts down the argument, so let's just stop right there. They did, fortunately, decide to get into the merits of the argument as well. And their argument essentially is well, the Second Amendment doesn't protect Duarte. Here's what they said. Contrary to the panel's decision, Section 922G1 is constitutional in all its applications and plainly in its application to Duarte. As an initial matter, felons are not protected by the Second Amendment's plain text because they are not part of the people under that amendment. The people includes only members of the political community, and felons have forfeited their membership in that community. States have long denied felons the right to vote, the right to hold public office, and the right to serve on juries. The Second Amendment does not preclude legislatures from making a similar determination with respect to bearing arms. Now, as we know, there's already one case that's been argued before the United States Supreme Court. That is United States v. Rahimi. We also know about the Range versus Attorney General of the United States case, as well as United States versus Daniels. It is our hope that the United States Supreme Court is going to start carving out some rather clear exceptions where individuals who are deemed dangerous may still need or be capable of being disarmed, but those that are deemed unlawful or irresponsible will have a path to right restoration. The United States Department of Justice, however, believes that that is just far too complicated, that courts, for whatever reason, are incapable of differentiating between a violent and non-violent felony. Don't believe me? Well, this is what they wrote in their brief. Finally, the panel confusingly focused on the fact that Duarte's prior offenses were non-violent. Because of the repeated references to Duarte's non-violent offenses, lower courts might easily mistake non-violence as the relevant standard, a result that would substantially invalidate the provisions enacted by Congress. Well, that's exactly what the argument is meant to do, is to invalidate some of the provisions enacted by Congress. But if you just read another couple of lines, the parentheses that come right behind the sentence, you'll see that actually what the United States government is upset about is if that's the standard, we won't get to disarm enough people. Don't believe me? This is the very next wording after what I just previously read you. Referring to data indicating that only 18.2% of felony convictions in state courts and 3.7% of federal felony convictions were for violent offenses. Simply, they will not get to disarm as many people as they want. They also go on to state, as the last few decades of litigation related to the Armed Career Criminal Act illustrate, determining whether a particular offense is violent is no easy task. So this is not an administrable constitutional standard. Now, one of the other reasons in which the United States government wants this court to accept review is that if this ruling stands, there will be a circuit split. Now, obviously, we want a circuit split because if there is a circuit split, that exponentially increases the likelihood that the United States Supreme Court will accept the issue to resolve it once and for all. As it sits right now, if this Ninth Circuit ruling stood, the Ninth Circuit and the Fourth Circuit would be standing on this side of the issue, while the 10th, 11th, 7th, and 8th would be on the opposite side, upholding the constitutionality of 922G1. Now, many think that this case is quite tantamount to the Range case, which is also sitting on potential petition to the United States Supreme Court. The United States government, on the other hand, no, they kind of think it's apples to oranges, as they put. Range held that Section 922G1 was unconstitutional only as applied to a civil plaintiff with a 25-year-old conviction for food stamp fraud. Range emphasized that its decision was a narrow one, tied to Range in his individual circumstance, and that its analysis concerned only the historical tradition of arming people like Range. So, the United States government is moving for a full en banc review of the Duarte decision. It is Washington gun law's prediction. Well, it's not really a prediction because this is just what happens every time you get stuff in the Ninth Circuit, is that the full Ninth Circuit will, in fact, swoop in, gobble it up, and immediately screw it up. The case, once again, is the United States versus Duarte. We will go ahead and link up the government's petition for review by the full circuit panel so you can geek out on it for yourself. Hey, by the way, if you got ideas for videos that we should be doing here at Washington Gun Law, go ahead and click on that link right there. Some of the best videos we ever did weren't really our ideas to begin with. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.